It's Nolan.
Mic check, yeah, my mic
Every
work.
morning I'm faced with heaven and hell, fighting my consciousness. See my vision clear as optometrist. I'm an optimist, a southern king. Hustle to get flooded chains. Grew up on Jewels and Wayne. Now niggas stacking like 100 ways. Walking this earth, I took control of my turf. Had to learn to protect my soul before I knew what it's worth. My homies had to work. I was clocking in at work. My virtuous reality done took us to the metaverse. Water with the lemon squeeze. Passport up in my jeans. Sticking to the code. Watching sucker niggas switching teams. I gotta grind. My fam eating off the strength of my dial. This industry gave me no favors. You can tell from my eyes. The money coming, had to fight for it. Meeting with them white boys. Trying to make a living with this mic card. Buzz going crazy. Got them straight up out the sight ward. My life story deeper than these niggas had to fight wars. It's Nolan. What's going on, beautiful people? It's the kid J Nolan here. Welcome back to another episode of Inside the Industry, your number one source for music, entertainment, commentary, and breakdowns. Technically, this would be my last video for the year for 2024, but I actually have something that's finna drop at 10 o'clock talking about Charleston White going on Club 520, disrespecting Angel Reese or whatever. Originally, that video was blocked by YouTube, but it ended up getting approved. So that will be dropping tonight. But this is actually the final video I'm recording for the year. So if you're tuned in right now, I greatly appreciate y'all. All 18, almost 19,000 of y'all subscribers, man. I greatly appreciate it. I don't take it lightly. I take it very seriously, as a matter of fact, which is why I debate with some people in the comments when they come acting a little funny. But nonetheless, I greatly appreciate y'all, and I want to say, going into the new year, if you're on channel members, I highly advise you to join us over on Patreon. Feel free to cancel the channel membership and just go over to Patreon, because that's where the exclusive content will be going based on copyright restrictions on YouTube. Even when I keep stuff unlisted, YouTube will block a lot of the times based on Universal's discretion when I try to use their content. So it's no way that I can really give y'all member exclusive content over here without it getting blocked. So the best way to do it would be joining on Patreon, okay? Just giving y'all heads up. But let's get into this whole Lil Durk situation, man. As we all know, Lil Durk is under investigation. He has a pending trial. Trial was actually set to start in about a week from today. And, this is a whole murder for hire situation. You know what I'm saying? They saying that Lil Durk been out here commissioning all types of craziness out in Chicago. We went through the whole scenario of, out in LA, out in Cali, when they hopped on the PJ, they was at hotels. Transactions have been made. They have actual footage of Durk associates following Quando Rondo around in Cali up till, the shooting that took place and ended up taking Quando's, I think, cousin. But all that withstanding, more information has been released about Lil Durk in this case. We're gonna go through it tonight. For anybody out there, just keeping it all 100 with y'all. Anyone out there that's like, yo, you're not a legal expert, why are you covering this? Well, if I wasn't covering it, people would be asking why I'm not. I talk about things that happen regarding people in the industry, whether that be music industry, entertainment industry. I know the majority of y'all understand, but sometimes I just got to speak to the couple outliers in the stands that just, the molasses doesn't reach the pancakes as fast as others, So that's all I'm saying. If you don't like it, you don't have to watch. There's legal professionals on YouTube that'll break this stuff down or talk about it too. But it's the last day of the year, man. I would love to give plenty of clarity going into the 25 for the people that just insist. Anyway, let's get to it. Now, Journalist Megan Cuniff is the one putting this out there. She says rapper Lil Durk is looking at a new trial date of October 14th in his MFH case in Los Angeles, according to a stipulation today from federal prosecutors and defense. Okay, so that's the first update, is that the original trial date was January 7th. They're proposing for it to be moved to October 14th of 2025. So they want this to be stretched all the way out. They want another 9 months of preparation. Okay. Maybe a baby is on the way. Who knows? Furthermore, she states, discovery includes approximately 230 gigs of evidence. What the fuck? Let's get to the paperwork, y'all. So here we are, filed as of today. It's a 16-pager. Okay. E. Martin Estrada, United States Attorney. Going up, this is where we at with it, man. United States District Court for the Central District of California. Plaintiff, United States of America versus Durk Banks, a.k.a. Lil Durk, a.k.a. Blood, a.k.a. Mustafa Abdul Malak. I guess that's his Islamic name. We've got Kevon London Grant. We've got DeAndre Dontrell Wilson. We've got David Bryan Lindsay. All as co-defendants. Okay? Plaintiff, United States of America, by and through its counsel of record, the United States Attorney for the Central District of California and Assistant United States Attorneys Ian Yanello, Gregory Stapes, and Daniel Weiner, and defendant Durk Banks, both individually and by and through his counsel of record, Drew Finling, Marissa Goldberg, Jonathan Brayman, and Christy O'Connor. Blase blah. They stipulate as follows. The first superseding indictment in this case was filed on November 7, 2024. Defendant Banks first appeared before a judicial officer of the court in which the charges in this case were pending on November 14th. The Speedy Trial Act, 18 U.S. Code 3161, originally required that the trial commence on or before January 23, 2025. Defendant Wilson first appeared before a judicial officer of the court in which the charges in this case were pending on November 15, 2024. Okay? So, due to the Speedy Trial Act, all of this was supposed to happen next month, right? That's what they're laying out here. January 7th, blah, 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 doop, doop, same shit. All defendants are detained pending trial. The parties estimate that the trial in this manner will last approximately 14 days. All defendants are joined for trial and a severance has not been granted. By this stipulation, the parties move to continue the trial date to October 14th, 2025, and to set the following briefing schedule for all motions other than motions in limine. A motions hearing date of August 11, 2025, motions to be filed by June 30th, oppositions to such motions to be filed by July 14th, and any reply briefs to be filed on or before July 28th. This is the first request for a continuance. Defendants request the continuance based upon the following facts, which the parties believe demonstrate good cause to support the appropriate findings under the Speedy Trial Act. All defendants are charged with violations of U.S. Code 1958A, conspiracy and use of interstate facilities to commit murder for hire resulting in death, 18 U.S.C. 924C1A3, C1B2, J1. All right, which includes use, carry, and discharge of firearms and machine gun, Jesus, and possession of such firearms in furtherance of a crime of violence resulting in death. Defendant Jones is also charged with a violation of 18 U.S.C. 922O, possession of a machine gun. The government is in the process of producing discovery to the defense, which includes, among other things, approximately 230 gigabytes of digital evidence, such as audio, video recordings, surveillance footage, and approximately 20,000 pages of reports concerning murder and other violent acts, photographs, witness statements, and medical documents. Holy shit. Drake came out and dropped 100 gigs on our head tops this year that Durk and his associates said hold our beer and our machine gun. Okay? You ain't the only one that got rocket launcher. Okay? 230 gigs? They got y'all entire lives for at least a year. They might got more gigs than my motherfucking laptop came with hard drive. God damn. Due to the nature of the prosecution and the number of defendants, including the charges in the indictment and the voluminous discovery, yeah, that's a great word, voluminous, voluptuous discovery that will be produced to the defendants, this case is so unusual and so complex that it is unreasonable to expect adequate preparation for pretrial proceedings or for the trial itself within the Speedy Trial Act time limits. Defense counsel represent that they have various substantive obligations which necessitate the continuance of the trial to October 14, 2025. The list of obligations for defense counsel is attached here too as Appendix A and is incorporated as if fully set forth herein. In light of the foregoing, counsel for defendants also represent that additional time is necessary to confer with defendants, conduct and complete an independent investigation of the case, conduct and complete additional legal research, including for potential pretrial motions, review the discovery and potential evidence in the case, and prepare for trial in the event that a pretrial resolution does not occur. They say, man, we need more time. I didn't know y'all had so much shit. Where did y'all get all of this? Now remember, there's said to have been multiple snitches in Lil Durk's entourage that have been rumored to have been informants for damn near a decade of this man's life. Listening, watching, and listening to the locks. Damn near. You know what I'm saying? This is a hip-hop channel. Defense counsel represent that failure to grant the continuance would deny them reasonable time necessary for effective preparation, taking into account the exercise of due diligence. So the attorneys here say we need way more time, homie. Y'all, there's no way y'all gonna start trial on January 7th. Okay? And just bombard us with all of this information, all this evidence, and we have no defense for. Please allow us more time. We need to talk. We need to do more research. We need to consider taking some plea deals. There's a lot that needs to go down. Okay? Defendants believe that failure to grant the continuance will deny them continuity of counsel and adequate representation. They say the government does not object to the continuance. The requested continuance is not based on congestion of the court's calendar, lack of diligent preparation on the part of the attorney for the government or the defense, or failure on the part of the attorney for the government to obtain available witnesses. For purposes of computing the date under the Speedy Trial Act by which defendants Banks and Wilson's trial must commence, the parties agreed that the time period of January 7th to October 14th, 2025 inclusive should be excluded pursuant to 18 U.S. Code 3161 H7A, H7B1, H7B2, and H7B4. Because the daily results from a continuance granted by the court at defendant's request without government objection on the basis of the court's finding that the ends of justice served by the continuance outweigh the best interests of the public and defendant in a speedy trial. Okay? Failure to grant the continuance would be likely to make a continuation of the proceeding impossible or result in a miscarriage of justice. The case is so unusual and so complex due to the nature of the prosecution and the number of defendants that it is unreasonable to expect preparation for pretrial proceedings or for the trial itself within the time limits established by the Speedy Trial Act. And failure to grant the continuance would unreasonably deny defendant continuity of counsel and would deny defense counsel the reasonable time necessary for effective preparation, taking into account the exercise of due diligence. Yeah, because they ain't going to get absolutely no sleep. They not going to get no lunch breaks. They not going to get no nothing, no family time, no games, no picking sons from school, daughters. No. For purposes of computing the date under the Speedy Trial Act by which defendant's trial must commence, the parties agree that for defendants Banks and Wilson, the time period of January 7th to October 14th inclusive, and for defendants Grant Jones, Lindsay, and Houston, the time period of January 14th to October 14th inclusive should be excluded pursuant to the same codes, pretty much. Okay? They say nothing in this stipulation shall preclude a finding that other provisions of the Speedy Trial Act dictate that additional time periods be excluded from the period within which trial must commence. Moreover, the same provisions and or other provisions of the Speedy Trial Act may in the future authorize the exclusion of additional time periods from the period within which trial must commence. It is so stipulated. Okay? We've got signatures from Durk's attorney. Say, I have carefully discussed every part of this stipulation and the continuance of the trial date with my client. I have fully informed my client of his speedy trial rights. To my knowledge, my client understands those rights and agrees to waive them. I believe that my client's decision to give up the right to be brought to a trial earlier than October 14th is an informed and voluntary one, saying that all of the client, Durk Banks, that's Lil Durk, other attorneys and co-defendants are signing off, waiving their Speedy Trial Act rights so that they can have time to act right. Okay? That's some crazy shit there. They got hit with the crazy audible. So at this time, we don't have any additional narratives. We don't have any additional information as of yet. It has not been released. I'm sure as the trial actually comes to fruition, more information will be released. We'll find out more details about what is actually on these 230 gigabytes of hard drive access. Because they talking about they got photos, audio, they have video, they have surveillance footage, they have medical records of these guys talking about commissioning people to be unalived. All types of gang activity, all types of, damning information that could definitely send them up the river immediately. They saying, hold on, we need way more time so that we could come up with a proper defense. Because if they ambush us with this, ain't no way we're gonna make it. But at this time, we don't have specifics. Now, getting back to Megan's report, Megan Cuniff, by the way, she says that Durk's co-defendant, Asa Boogie Houston, is opposing the trial continuance, okay? So this person does not want to wait until October 14th of 2025. Their trial date is scheduled for January 14th, and they feel like they're not trying to push it back. I don't know why. Perhaps they're considering a plea. Perhaps they're going to just accept the judgment. Perhaps they snitching. I don't know. But, I ain't trying to put that on nobody's jacket, just for clarity. But they say after receiving a signed stipulation from all other defendants, the government was informed by counsel for defendant Houston that defendant Houston objects to a continuance of the trial date. The government respectfully submits that there is good cause to continue the trial date as to all defendants, including defendant Houston, pursuant to USC 3161H6, because the time period of January 14th, 2025 to October 14th, 2025 inclusive constitutes a reasonable period of delay for defendant Houston, who is joined for trial with the stipulating defendants as to whom the time for trial has not run and no motion for severance has been granted. So he don't want to be included in that continuance, but it'll probably be overruled, right? She then says at least one of Durk's co-defendants may be considering a plea deal. DeAndre Dontrell Wilson's lawyer asked for a pre-plea sentence report to determine Wilson's criminal history category under U.S. sentencing guidelines. Judge Michael Fitzgerald opened the report on December 27th. Okay? So at least one of these guys has a pre-plea sentence report that's being evaluated. Okay? Order granting unopposed ex parte application for preparation of a pre-plea pre-sentence report. Okay? So Dontrell may be trying to work something out on whether he can, a lot of times pleas are for reduced sentencing or what have you. Right? They say this is Durk's detention order, as of course he remains in custody. On November 14th, defendant Durk Banks made his initial appearance on the first superseding indictment filed in this matter. At defendant's request, the detention hearing was continued to December 12th. A detention hearing was held on December 12th. At the hearing, the government proffered the complaint, the first superseding indictment, the government's brief in support of pretrial detention for defendant Durk Banks and exhibits 1 and 2 attached thereto, and the pretrial services report and its recommendation of detention based on danger to the community. Defendant proffered documents reflecting that he has obtained a monthly lease at a property located in this district, that he has engaged a full-time bonded and insured security company, the specifics of which were provided to the court, that he is a highly successful musical artist signed to Alamo Records, a subsidiary of Sony Entertainment, that he has significant assets, a detailed accounting of which was provided to United States Probation and Pretrial Services, that 2 houses he owns have a combined appraised equity of $2.3 million, supporting documentation provided, which he is willing to post as collateral to secure his release, and that multiple third-party guarantors, including Alamo Records, are willing to support his release with cash and property. So at this time when this was filed, they're trying to get him out. He's willing to put his 2 homes up as collateral. Even his record company, Alamo Records, is willing to put up cash and property in his defense for him to be at least released, I guess, until trial. Defendant also proffered a 2023 annual report of Neighborhood Heroes Foundation, a nonprofit organization founded by defendant to make positive change in the lives of those within under-resourced neighborhoods across the country, and a copy of an e-ticket itinerary and receipt in his name for flights on United Airlines on October 24th and 25th from Newark to Zurich, and then from Zurich to Dubai, and a declaration of Justin Gibson regarding a January 25th, 2022 recording session with defendant. The court reviewed and considered all of these materials and the arguments of counsel. On motion of the government, 18 U.S.C. in a case allegedly involving a crime of violence. On motion of the government, 18 U.S.C. 3142 F1 in case allegedly involving an offense with maximum sentence of life imprisonment or death. The court concludes that the government is entitled to a rebuttable presumption that no condition or combination of conditions will reasonably assure the defendant's appearance as required and the safety of any other person and the community. The court finds that the defendant has presented evidence sufficient to rebut the 3142 E2 presumption, but after considering the presumption, the factors set forth in 18 U.S.C. 3142G, and all of the information and argument presented at the detention hearing, the court concludes that the defendant must be detained pending trial because the government has proven by clear and convincing evidence that no condition or combination of conditions of release will reasonably assure the safety of any other person in the community, by a preponderance of evidence that no condition or combination of conditions or of release will reasonably assure the defendant's appearance as required. In addition to findings made on the record at the hearing, the reasons for detention include the following. So here's their reasons outside of those codes. They say on August 18, 2022, defendant allegedly texted a co-conspirator with instructions not to book flights to California under a name involved with defendant. See first superseding indictment, docket number 27 at 7. On October 24, 2024, shortly after the co-conspirators were arrested and multiple search warrants were executed in this case, the FBI received notices that defendant is Durk, had been booked as a passenger on 2 commercial international flights departing that day, neither of which he boarded, and that he had booked as a passenger on a private plane departing Miami that same day and destined for Italy. At the hearing, defendant's counsel offered the itinerary and receipt for one of those flights. This evidence supports the interference that defendant, who has considerable resources, attempted to leave the U.S. upon learning of the arrest of his co-conspirators. Defendant formed Only the Family, known as OTF, which in addition to producing and selling hip-hop music, is also alleged to be in association, in fact, of individuals who engaged in murder and assault at defendant's direction and to maintain their status in OTF. In this case, defendant is alleged to have orchestrated and funded a murder plot in which his co-conspirators, acting at defendant's direction, traveled to LA, tracked, stalked, and attempted to unalive defendant's intended target by gunfire, including a fully automatic firearm in broad daylight in a busy Los Angeles intersection, and did kill a family member of the target who was traveling with him. In a separate matter in Chicago, defendant is alleged to have engaged in similar conduct, that he offered money for people to unalive those responsible for his brother's killing, and more specifically offering to pay money for any GD that is killed. The material proffered by the government supports the conclusion that defendant uses his money, influence, and power to endanger individuals whom he perceives as a threat. It is therefore ordered that he must be detained until trial. Okay? So that was just a few days ago. On the 16th, they determined he will have to sit. Now he will have to sit at least until October. Okay? Now, let's get to Jay-Z. Because remember, we just talked about Jay-Z filing his motion for the for his case to be dropped. We now have an update that Mr. Tony Buzbee is refuting that request. Okay? So let's share the screen and go through this real quick. Buzbee Law Firm, written in them big ass headline letters. We already know they writing to Annalisa Torres, the judge. They state, Your Honor, I write on behalf of plaintiff Jane Doe in response to defendant Sean Carter's letter dated December 30th, 2024, pursuant to which defendant requests leave to file a motion pursuant to Federal Rule of Civil Procedure 12B6 to dismiss plaintiff's first amended complaint. Okay? Defendant states his intention to move for dismissal on the grounds that Doe cannot pursue her claim under the New York City Victims of Gender Motivated Violence Protection Act, NYC Admin Code 10-1101, because the GMVA does not have retroactive effect. That's what Alex Spiro and Jay-Z's counsel say. However, neither the Second Circuit nor the New York Court of Appeals has endorsed this reading of the GMVA. In support of his argument, defendant cites a trial court order decided on an unopposed record, which is merely persuasive authority. Okay? Plaintiff failing to address GMVA retroactivity issue. And of course, the retroactivity issue that Jay-Z and them pointed out is that this alleged incident happened before the GMVA, Gender Motivated Violence Protection Act, was created. Okay? Which I thought wasn't that strong of a argument, but again, you got to try. They say defendant's argument as to the GMVA is unpersuasive, as it is contrary to the law's primary intention to make it easier for victims of gender-motivated violence to seek civil remedies in court, not, as defendant would have it, make it harder. New York City passed the GMVA in light of the void left by the Supreme Court's decision in United States v. Morrison, NYC Admin Code 8902. Morrison struck down the federal right of action for victims of gender-motivated violence under the Violence Against Women 42 USC blase, holding that Congress lacked the authority under the Commerce Clause or the 14th Amendment to pass such a remedy. The Supreme Court, however, urged local governments to provide a remedy to women like Morrison who had been brutally raped, as to no civilized system of justice could fail to provide her a remedy. New York City rallied to that call and passed the GMVA. Okay? The city council recognized that gender-motivated violence is widespread throughout the United States and that 3 out of 4 women will be the victim of a violent crime sometime during their lives. NYC Admin Code 8902. The council also concluded that victims of gender-motivated violence frequently face a climate of condescension, indifference, and hostility in the court system. So this is Tony Buzbee with his rebuttal as to why that first, reason for dismissal was not valid in their opinion. And I got to be honest, when I read that request, I wasn't convinced, right? But I, of course, am not a legal professional. I'm not a legal expert, as they generously point out, which I've never claimed to be, ever. I've always said, for all my folks that practice law, feel free to let me know what's going on, right? But people don't pay attention to stuff like that. They continued, the council sought, therefore, to create a private right of action for victims of gender-motivated violence to resolve the difficulty that victims face in seeking court remedies by providing an officially sanctioned and legitimate cause of action for seeking redress for injuries resulting from gender-motivated violence. Okay, NYC Admin Code 8902. It is fundamental that in interpreting a statute, the court should attempt to effectuate the intent of the legislature. Okay, the council intended the GMVA to make it easier for victims of gender-motivated violence to seek court remedies, and it intended the same when it passed the 2022 amendment to the law. Okay. Similarly, defendant also intends to seek dismissal on the grounds that any viable GMV law claim is time barred under New York's Child Victims Act, which preempts plaintiff's GMV law claim. However, this court in Doe v. Gooding found that local anti-discrimination laws are generally not preempted by state law in New York. Interesting. Finally, defendant intends to seek dismissal on the grounds that the conduct alleged in the FAC could not have occurred in New York City. Now, that part I thought was actually pretty accurate, because we can't be for sure that this young lady ever went to New York City. Based on plaintiff's description of the residence in question combined with public records, confirms that any such residence was located outside of New York City. As defendant seeks to rely on evidence outside of the pleadings, which would transform a motion to dismiss to one for summary judgment, and as discovery is not yet underway, it is respectfully submitted that defendant's proposed motion is procedurally improper and should be denied. They say, in light of the foregoing, plaintiff respectfully requests the court to deny defendant's request to file a motion to dismiss. Of course, that's from Anthony Buzbee, aka Tony Buzbee. And as a neutral party, as a layman reading this, I don't fuck with Tony Buzbee at all, but I can't say I disagree with his rebuttal here. As much as that's going to make Jay-Z's life a little tougher, to where they actually may have to proceed in a trial, based on my limited understanding, and I'm pointing this stuff out because you're not a legal professional, so let me play myself as dumb as possible. According to my estimations, that last request for dismissal, it was kind of weak. Now, as far as the New York City thing, I thought that was their strongest claim, because again, we don't know for sure. We don't know at all if this young lady traveled, and she was a young lady at the time of documentation of this alleged incidents, that at 13 years old, she traveled 5 hours with a phantom friend to New York City to go be at the VMAs. She had no ticket to get into the VMAs. She was watching the show on a Jumbotron that never existed. She was walking around talking to motherfuckers that were never there. She got into a party at a house that we still have not been able to corroborate its existence. So that last part, I feel that the whole New York City thing was their strongest piece. Do I think that the judge is going to favor Jay-Z's request for dismissal off of that alone? Probably not. I would be surprised if they do. But I'm still under the belief that Jay-Z did not do this. I'm still under the belief that Diddy did not do this, although he has enough on his fucking jacket to state that nigga ain't shit. But in the interest of fairness, I gotta say when I think something is strong and when it looks weak. And I know some people will agree or disagree. It really doesn't fucking matter. I'm used to it by now, you know? But that's what we had from Tony Buzbee with his rebuttal as to why he doesn't believe that his case should be dismissed. Now, I am curious to know what Tony Buzbee thinks he has, because this is about the second time to my knowledge, or at least just me thinking here, that he's mentioned that we're not yet in the discovery phase. Tony Buzbee seems pretty confident that he has some sort of evidence that could possibly sway this entire thing. I don't know what he has. I don't know what he thinks he has or what. You know, so it's going to be very interesting keeping up with this whole thing because I don't know what he thinks he has up his sleeve. And in Jay-Z's case, I mean, what he has is, how can you place me at the scene that y'all are purporting happened if it didn't exist? If this White House property of Diddy's, we've determined that none of his properties line up with the description in the timeline. We've also established that this young lady's, and she's now grown, but her father cannot attest to her story of ever picking her up from New York City in the middle of a fucking night, taking her back home. The one witness who supposedly took her to New York City is allegedly dead. She said she spoke to Benji Madden from Good Charlotte. Them motherfuckers said, no, you didn't, because we wasn't even at the VMAs. We was in the Midwest. Fred Durst ain't came out and said shit. She claimed she talked to him. His ass ain't said a motherfucking thing. I'm sure he wants to keep it that way. They may have to find his ass for the trial. We still got the unnamed celebrity, the woman that was supposedly in the room. A lot of people are thinking that they're trying to throw J-Lo into this. It'll be very interesting to see who that unnamed woman is, if they're going to try to, if Buzbee's going to add that name, or if he's still trying to extort them out of money. Who knows? I don't believe this shit occurred at all. But again, I don't know what this guy thinks he has as a gotcha. You know? So let me know what y'all think of all this down below in the comments. Be sure to like and share this video. If this is your first time seeing me on YouTube, go ahead and subscribe to the channel, become an insider. Let me know what y'all think of the Lil Durk shit too. The 230 gigs of evidence that might be putting him away for life nearly. Do y'all think he may be going away for life? Do y'all think they're going to work something out? Is he going to take a plea? We're going to see. And based on their filing, they're asking for the date to be moved to October of next year. So it may take a while before we actually find out what's going to happen with Durk and his associates. All right. Again, I'm going to catch y'all later. Happy New Year. Be blessed. Love on your family. And again, I have another video that's about to drop shortly after this with the whole Charleston White Angel Reese thing. But I recorded it earlier in the day and YouTube finally decided to stop acting like hoes. All right. I'm going to catch y'all later. Be safe out there. Please be safe. I know New Year's, y'all be having fun. Y'all want to turn up and shit, man. I'm in the crib with my family, setting a precedent. So, best wishes to everyone that's going to hit the streets. All right. I'll catch y'all later. Peace. King of my city and cul-de-sac. Coming out swinging like soldier rags. Leading my people like quarterback. Boy, I study this shit, I'm an almanac. Had to get up and grind. Knowledge is booming, I'm here to apply. Came with the chip and the dip, it just single the mind. We finna do more than survive. I need my check. Spinning the block for the Gouda. We hitting the jeweler to flood out the net. We don't do beef for computers, I'm straight out the sewer. We come when you rest. Niggas be looking perplexed, so keeping my foot on their neck. No map, I trust my gut for the quest. With drama, I'm fully abreast. I was ready for years and they doubted me. All of a sudden they tell me they proud of me. I been dropping these haters like calories. Cross them out, I came back with some boundaries. Stand for my honor, but too raw, no corner. Packing the stick with a drummer. When I catch my bad, won't fumble. I done came too far to be humble.